My name is Dustin Saldarriaga, and I'm an associate with Scott Legal PC. It's a pleasure to be with you this morning. If you're here, you may already have an E-2 visa or may just know a little bit about them, or maybe you know a lot about them, and everyone in those categories is in the right place. Our firm was actually founded on an E-2 visa about 8 years ago. Our firm is a full-service immigration firm, though we do have a focus on business and investment visas, and we've processed hundreds of them. Today, we'll be covering the fundamentals of the E-2 visa, including how to get one and how to renew one if you already have one. A few things before we get started. This webinar is part of a series, and we will continue the series by doing at least 2 webinars a month on a variety of immigration topics. We already have a number of webinars scheduled, and we will regularly add more. You can find these webinars on our website. At the end of this webinar, we'll send out a few things to you all. First, we'll send out the PowerPoint presentation, which you see on screen. We'll also send you a link to where you can sign up for the additional webinars. And since this webinar is being recorded, we'll be sending you a link where you can find that recording. I also want to sharing it to our, and on our YouTube channel, we include our past webinars, as well as a number of shorter videos on a variety of immigration topics. A few housekeeping items before we get started. We do plan to reserve a few minutes at the end of the presentation for questions, but we will also be answering questions that are raised throughout the presentation. The way you can share those with us is you can either use the chat function on Zoom, or you can use the question and answer function, and we will be monitoring those throughout the presentation. Again, my name is Dustin, and I am a presenter as well as a moderator for this webinar. My co-presenter and co-moderator is Michaela Vrazdova. We're very fortunate to have Michaela here as well speaking with us. She is also an associate at Scott Legal PC and has a wealth of experience on E-2 visas, as well as a variety of the visas we handle at our firm. Michaela will be covering the renewal portion of this presentation, and we'll also be monitoring the questions that you all ask. So without further ado, let's go ahead and dive in. So the E-2 visa is actually a fascinating visa. It is rooted in treaties that the United States has with countries around the world. It is a non-immigrant visa, which means that it does not directly lead to a green card or permanent residency. It is for a temporary stay in the United States, although it can be renewed indefinitely. It allows nationals of certain countries, those being countries that do have treaties with the US, to come to the US specifically to develop and direct the operations of an enterprise that they have invested in. There are a number of options for obtaining an E-2 visa. Typically, this is where a national of a treaty country has either started their own company or plans to start their own company in the US, or they could be buying a company in the US. A final option here that I would add that we see quite often is an individual could be starting a franchise in the US. So a common example is that, say, for example, a national of the United Kingdom wants to open, say, a Subway sandwiches franchise, let's say in Virginia. They would invest in that franchise, and through that investment and their direct operation of the company, they would then apply for an E-2 visa, and we'll cover those that in detail. So again, there must be a treaty between the US and the foreign countries. The United States has treaties with, I believe there are about 80 countries on the list at this point in time. They do occasionally change, though rarely. Countries include those in Latin America, the Middle East, Africa, Asia, and Europe. We have clients around the world who are pursuing E-2 visas. The most common countries that we see, although this is not representative of necessarily who around the world is applying, is Germany, the United Kingdom, Canada, also Japan and South Korea. E-2 visas are quite popular in those countries as well. E-2 visa validity. So the visa itself, the maximum amount of time that an E-2 visa can be issued for is 5 years. Although there are certain exceptions to that. In certain countries, there is reciprocity with the US, where the US will limit the period of time that the visa is valid for. For example, certain countries, you may have a visa that's only valid for 3 months. That is rare. Typically, the visa is issued for the maximum period of 5 years, but do be aware that exceptions do exist. All right. So the requirements for an E-2 visa. The first requirement is that the applicant must make an investment. One of the most common questions we receive is, how much do I need to invest in order to receive an E-2 visa? And unfortunately, there actually is not a clear number that the United States government publishes on this question. What they do say, however, is that the amount that is invested needs to be sufficient to essentially make the company operational. So as an example, if someone is applying based on a manufacturing company, an example we like to use is, say someone's starting a car manufacturing company in the US. That company would require a large investment amount, likely several $1,000,000, because that's the amount that's needed to get the company operating. In contrast, people who are starting a consulting firm, say, with starting off with 1 or 2 people, that's just giving business advice. That kind of a company has very low overhead. It could be that an investment amount of $50,000 or in that range may be sufficient. Our firm, a law firm, it tends to have low overhead. I believe that our firm was founded on approximately $50,000, and that was sufficient for the initial application. The other thing that's important to keep in mind is that certain consulates have more strict requirements. Again, these are not necessarily published, but we do see that certain consulates are stricter than others when it comes to investment amount. The money that's invested does need to be at risk, which means it needs to have been spent. It's not sufficient to simply transfer an amount of money from someone's personal account into a business account and let it stay there as, say, working capital. The money actually does need to be spent on the business. Very common examples of expenditures that we see are, for example, commercial rent. You can pay for rent in advance, say 6 months in advance. That tends to increase the investment amount quite significantly. You can also pay for inventory if that's relevant to your business, equipment, a website, office supplies, legal fees to get the business set up. You can also pay employees, even if you're not actually in the US. You can hire, for example, an office manager who's taking care of things in the United States, and you can count those payments toward the investment amount. One other thing that we like to point out is that if a lot of people, because the money needs to be at risk, a lot of people are very hesitant about actually spending tens of thousands of dollars at least to get a business started before they even have a visa. So for people who are purchasing a business in the US and don't want to put that amount of money at risk, they can use what's called an escrow account, where essentially the money for the purchase of the business is put in escrow. And the only condition before that money is released is issuance of the visa. And so what we would do in that kind of an application is we would submit with the application to the government the escrow agreement that makes clear that to the government that as soon as they issue the visa, the money is released, which effectively makes it committed to the business, and that the government does accept that. Source of funds is also a critical piece of the investment. So the government requires that applicants show how they got the money that they are investing in the business. This can be from a range of sources. Some people have saved money from a job that they have. Some people have sold a piece of property and are investing that money in the business. Some people have received a gift from a friend or a family member. All of these methods are fine. The requirement, however, is that the person be able to document how they got the funds. So to take an example, if they sold a piece of property to invest in the business, they would provide a copy of the agreement showing that they sold a piece of property for a specific price. They would also need to provide, say, bank statements, for example, that show that funds arrived in their account from a specific source. And the idea behind this is really that the government wants to make sure that funds were acquired through a legal means. So they need to verify that there was no illegal activity that resulted in the applicant having these funds. The second major requirement for an E-2 visa is the business cannot be marginal. What this means is that the business needs to be able to financially support more than just the applicant. The business actually needs to pay employees, in other words, and what we typically recommend is that the business show that over the course of 5 years, it will be able to employ between 3 and 5 full-time US employees. The business also must be real and operating. So what that means is essentially what the government wants to see is that, and this is related to what we were talking about with the escrow agreement. The government wants to see that the only thing the applicant needs is the E-2 visa before the business is actually operating. So an E-2 visa is not a visa for someone to come to the US and at that point begin talking to people about what the business might be, forming relationships. It's not, for that typically a B1 visa or possibly ESTA would be appropriate. In contrast, the E-2 visa is really for people who have everything lined up for the business, and all they need to do to begin generating a revenue is get their E-2 visa and arrive in the US. So what that means for the application is that we do include in our applications a signed commercial lease. We include evidence that a business bank account has been set up. We include, again, related to what we were talking about before, evidence that things that are necessary for the business to operate have been purchased, whether that's inventory, office supplies, paying an employee, having a website created. We also really do, although this is not required, we do find that applications are strengthened when we can include contracts that the business has with prospective clients or customers, which we call letters of interest. And of course, any licenses that might be required for the business. For example, if someone's looking to open a fast food restaurant, let's go back to our Subway sandwiches example. Obviously, there are certain health department licenses that you would need to sell food. You would need to have those lined up by the time you submit your application to show the government, again, that this is a business that's ready to operate as soon as the applicant gets the visa. Another requirement for the E-2 visa is that the applicant must solely develop and direct the E-2 enterprise. An E-2 investor is supposed to come to the US specifically for the purpose of developing the E-2 business. That is supposed to be their focus. And where this can get tricky is where, for example, the applicant is also providing direct services to clients, especially if an applicant is applying through USCIS, which is where people who are within the US would apply through USCIS for E-2 status. If you're outside of the US, you would apply for it through a consulate. We find that USCIS is very particular about looking at whether the E-2 investor applicant is providing direct services to clients, and they don't like that because essentially the E-2 investor is not supposed to be competing on the open market with people who could presumably do the work here in the US. So just to go back to our example of the Subway sandwiches franchise, the E-2 investor would be fine if the E-2 investor is spending their time marketing, hiring, managing employees, looking at partnerships, expanding the business. What would be problematic is if the E-2 investor at that sandwich shop is actually there making the sandwiches and spending a lot of their time actually serving customers. If that individual were applying through USCIS, we would really have to work with them to make sure that that's not the bulk of their time. And really they will be what's called developing and directing the business. Another real, go ahead.
Question. Someone just had a question whether the initial investment should be made before or after the visa is granted.
Yeah, absolutely. So the initial investment has to be made before the visa is granted, and we would include documentation proving that in the application. So when we send the packet of information to the consulate or to USCIS, we would include there all the documentation showing that you actually have committed the full investment amount to the business. Full amount meaning an amount that's enough to make the business operational.
So it's not just sufficient to have the money on a bank account and kind of invested when the person comes to the US, correct?
That's correct. That's correct. That is not sufficient. If an applicant has both spent a sufficient amount on the business, but then also has an amount in their business bank account that has not been spent, we would share that with the government. We wouldn't rely on working capital. We call that amount that's reserved in an account and really committed to the business that hasn't been spent yet. We call that working capital. Working capital, we wouldn't depend on that to satisfy the investment amount. We can, though, share with the government that in addition to the funds that have been committed, we also have a working capital amount. And that's just, kind of additional persuasive evidence, though, again, we wouldn't depend on that to satisfy the investment amount. I see there are a couple other questions.
So let me see. So one is, how does that work if the applicant is a manual worker and it's a manual business? Their time can't be spent directing the business from an office if their job is hands-on.
Yeah, it's a really good question, and it can get tricky. It can get tricky. So for example, where this does come up, it would rarely come up in a Subway sandwiches, because a Subway, you're probably going to have a manager and clearly have employees who are making sandwiches. An example where it does come up and it's quite challenging could be, for example, say a law firm or an accounting firm, where the applicant is the accountant or the lawyer and is going to be providing direct services. So a couple things I would say on that. First is, again, consulates tend to look at this less than USCIS. So that could be part of the discussion. If it's an option whether to apply through USCIS or a consulate, if you are starting a business like an accounting firm or a law firm where you really do need to be providing some direct services, we might encourage you to apply through a consulate rather than USCIS. But more fundamentally, I think it's really thinking about the business in a slightly different way, where you kind of need two lenses on the business. You need to think about the business obviously as a business owner and to do things that make the business successful. But you also have to think about the business as something that the government needs to approve of. And sometimes that requires you to make decisions you wouldn't make if you were, just a very, wise and savvy business person. So an example, putting a lot of money into a business up front is not necessarily a good business practice. It is what the government requires. And this point is kind of related to that, where, even if you're an accountant and it would be most beneficial for you to be doing 100% of the direct services, build the business, and then only when there's a need to hire someone. If you are applying for an E-2 visa, you might need to change that a little bit and think about, okay, there are certain tasks that I could do, but that I'm going to hire someone to do instead because it is in line with the E-2 visa requirements. So I might hire an office manager. I might hire earlier than I would have another accountant who can start to take on this work. And my role would be primarily to supervise that work and only to do direct services in a minority of my time and in only specific cases. So, that's really how you have to think of that. It can be tricky, and it oftentimes does require strategic conversation with the client.
There is one more question. Someone is asking, how can I demonstrate my willingness to return to my home country? So is this like similar as a B visa? Like, does the person have to kind of show ties to the home country, or how does it work?
Yeah, that's a great question. So basically, it's a very straightforward piece of evidence. What we tend to do is in our applications, we would include what's called a letter of intent to depart. And it's just a one-page letter saying, I, Dustin, agree that at the expiration of my E-2 visa, I intend to depart the United States and return to my home country. And then you would sign that, date it, and that's what we submit. For the E-2 visa, the government tends not to look for substantial evidence of ties to the home country, such as a lease, a mortgage, a bank account. We find that it's very rare that a consulate would ask for that. The one thing I would add to that, though, is for the United Kingdom, the nationals of the United Kingdom, there is an additional requirement that they show that they are residents of the United Kingdom. For that, we would have to include additional evidence that within the past few years, you have paid taxes in the United Kingdom, paid for utilities, that you have a lease in the United Kingdom. We would have to show some additional ties if you are a national of the United Kingdom. But otherwise, it's fairly straightforward and thin evidence, frankly, that the government requires. All right, so we were talking about ownership. So this is very fundamental. For the E-2 visa, you must be a national of a treaty country. We mentioned that before, and you must own at least 50% of the E-2 business. That is a threshold requirement. If the E-2 investor applicant owns less than 50%, they simply don't qualify for the visa. And if their ownership over the course of having an E-2 visa actually drops below 50%, they become ineligible for the visa. So that's something they have to pay attention to. If you are, very involved with a business, you are a national of a treaty country, and you just don't satisfy that ownership requirement, we could talk about an E-2 employee visa, which does allow businesses that are registered as E-2 businesses, which means they're owned by nationals of an E-2 treaty country. It allows them to hire nationals of the treaty country to come to the US in either a management, an executive role, or as a specialist for the business. But for investors, you do need to have at least 50% ownership. And that can be split between two people. So if two individuals each own 50% of a business and they are nationals of a treaty country or two treaty countries, they could both qualify. Finally, we touched on this, but you must have intent to return to the home country upon expiration of the E-2 visa. And since we talked about that before, I'm not going to add too much to that point. But the E-2 visa is a non-immigrant visa. You do need to have intent to return. However, that being said, the E-2 visa can be renewed indefinitely. There is no maximum period of time through which you can have an E-2 visa. Our firm was founded on one, and it's been operational 8 years, and we expect it will continue to be operational for a significant amount of time in the future. And fortunately, we don't have to worry about that because there's just no limit on the E-2 visa renewals. Okay, so I also, you touched on this before, but the investment amount does need to be substantial. This is a common question we get. There is no minimum set amount by the government. It depends on the type of business, which we talked about before. A manufacturing business will require more than, say, consulting or an accounting firm, for example. One of the helpful methods that the government has established is what's called the proportionality test. And again, that question kind of goes to how much money do you have to invest in the business to establish that type of business? And there are pieces of evidence you can include and that we would, in certain circumstances, include in an application to really convince the government that for a certain type of business, you really don't need to invest, $200,000. Say for a consulting firm, you only need to invest $50,000. We would have to make that argument to the government. And to do that, we would use either publications in magazines and online publications, for example, that talk about how much it costs to start a certain type of business, or we might encourage the applicant to get a letter from a CPA, where the CPA will actually review how much has been invested. We'll take a look at how much is usually required for a type of business, and we'll share a signed letter saying, I'm an expert, I'm a CPA, and based on my understanding, this is a sufficient amount to start this business. And the test would look different between if the applicant is buying a business, is starting a franchise, or is starting a startup. For a startup, it can sometimes be tricky and require additional evidence because there's really no track record to point at. When someone's purchasing a business, if the purchase is at an arm's length, which it would need to be, in other words, the business is available to be purchased by anyone, and the price established really is the market value of the business, that's a strong argument that a substantial amount has been paid for the business. Franchises, frankly, tend to be the most straightforward here, because a franchise is not going to sell a franchise for less than is required to get the franchise started. That's the franchisor's business. So we would show the franchise agreement, the franchise disclosure document, and really show that a substantial amount has been invested in that business.
So Dustin, someone is asking, for a technical consulting business where two people are investing as 50% partner, would $50,000 as an investment, as a committed investment, and $50,000 as a working capital be sufficient as an initial investment?
Yeah, so I'll start with the caveat that, again, there is no amount that we would typically say on the face of it, yes, that's enough. Again, the government has not published a specific amount. They've not said if you have $50,000 invested, you satisfy the requirement. So basically how we think of it is we look at it in the holistically as part of the whole application. And we would look at how many employees you plan to hire. We would look at, is this a startup or is this a franchise? Is this purchasing an existing business? And we would have that conversation with you. On the face of it, I will say our firm has handled consulting businesses that have invested $50,000 with $50,000 in working capital. And that piece of it has not been an issue in those applications. But again, that would depend on where you're applying. That would depend on the application holistically. So if you really want to go into depth, we can talk about that during a consultation. But on the face of it, that would probably be sufficient, but toward the low end of what would be.
And I think in this case, we maybe would suggest to invest a little bit more just because it's two investors. So we had cases when the investment was like $30,000-$40,000 for one investor, but because it's two, maybe we would suggest to invest a little bit more.
Perfect. All right, do I have to hire employees? The answer is yes, but not right off the bat. So this is the marginality requirement that I mentioned before. One of the fundamental requirements is that the business cannot be marginal. So the business must support people other than the E-2 investor. What we tend to recommend is that the E-2 business over the course of 5 years show projections that it will employ at least 3 to 5 full-time US employees. That's kind of, the baseline of what we see tends to satisfy the government. However, it really is dependent on the business itself. If this is a large business and you've projected at the initial application stage a lot of hiring and very little has occurred, that could be a flag to the government as well. But what the requirement is that the E-2 business must have the present or future capacity to generate enough income to provide more than a minimal living for the E-2 applicant and their family. So how do you show this? So basically, if this is a startup, this makes the business plan especially critical, because what a business plan does is it shows projections, and business plans that we will prepare for our clients show 5 years of projections. Those are projections of revenue, projections of profits, as well as projections of hiring. So for a startup, a business that is not already operational, but will be once the applicant gets the E-2 visa, we would really focus heavily on that business plan, and it would be a really robust plan that supports whatever projections are in there. For an existing business, in the application, we would provide evidence that the business is already employing people. That could be W-2 tax forms for employees. It could be 1099 tax forms for independent contractors. It could also include payroll records showing how many people are on payroll. And that touches on another element, which is that even though the ideal is 3 to 5 full-time US employees, the government will consider both part-time workers and 1099 contractors. So if your business is contractor dependent, we would certainly want to include that as well. And finally, the final point I want to raise here is it's not necessary at the initial application phase to show that you're employing people. Again, what is important is showing that you're on a trajectory to hire and employ people over the course of 5 years. So it's fine if it's just you at the beginning, as long as you can back up those projections, that is okay. But one thing we do work with clients on is framing that. So if it is possible to have the company hiring within the first year or within the first 2 years, that does tend to strengthen an application. And we really do like putting in kind of front and center in the application. This is a business that is going to hire people in year 1, is going to generate revenues, is going to generate a profit in year 1. If we can say that, that's great. If we can't, then we work with our clients to frame it as best we can to show that they're hitting those marks within at least 5 years.
Dustin, someone has a question whether the spouse of the E-2 investor counts as one of the employees.
Well, that what the spouse is doing. They would only be counted an E-2 employee if they actually are working for the business. But I think what the question is getting at is whether that requirement of 3 to 5 employees can include family members. And the answer is that it should not. Ideally, the government is going to want to see, again, that this is a business that's going to support more than just the investor and their family. So we really do want to show that this is a business that's hiring people who are on the open market looking for jobs and is not, just employing a spouse, for example. But it's a good question. All right. Business plan considerations. So I just touched on the business plan a bit. Business plans are, in general, a very important part of an E-2 application, especially when the business is a new business. And that's because, again, the business plan is really the place where you can show that this is a business that will generate revenues and will employ people. For existing businesses, the business plan is less critical, but still can play a key part in the application, because what the business plan really does is it gives the government a single document that really gives a lot of detail on what the business is, who the E-2 investor is, what the market looks like, what competition looks like. And that's information that even if you have an existing business, may be hard to convey if you don't have a business plan. So, frankly, there are few, if any, situations in which a business plan is not a good idea, but certainly it is especially important for new businesses. For existing businesses, some of the information that would be in a business plan could be contained in, for example, tax returns. So if you have an existing business, you've purchased an existing business, and you're trying to show the government that the business satisfies this marginality requirement, you would include, for example, tax returns, corporate tax returns for the last 3 years, and show this is a business that's paid $100,000 in salaries to employees. That's a really good way to show it's a business that'll support employees. And in those cases, a business plan is less critical. And here on the PowerPoint, you see kind of the key elements of what we would include in a business plan. I touched on a few of these. So it would have an executive summary. This is really a core piece because, frankly, consular officers oftentimes don't spend a lot of time reviewing applications before they interview applicants. If they are going to spend 10 minutes reviewing your application before your interview, the executive summary of the business plan is probably one of the places they will go. So really a key piece to get them the key information they need to understand why they should approve your E-2 visa. A business plan would also include market analysis, a marketing plan, how you plan to generate business, a personnel plan, your 5-year hiring projections, a comprehensive financial plan showing how you will generate revenue and profits. And finally, do I need to hire a professional? You do not need to hire a professional. The one thing, though, that's important to say is that the business plans that we prepare and that if you're applying for an E-2 visa, you should submit are not, normal or general business plans. They really are catered to the US government being the reviewer. So when we create a business plan, it really is keeping in mind, well, what is a consular officer going to be looking for when they look at this business plan? What is USCIS going to be looking for? And so in that respect, it could certainly be helpful to hire a professional to prepare your plan. All right, I am going to pass it off to Michaela. I know we are about halfway through, so Michaela, I will pass it off to you.
Thank you so much, Dustin. Yeah, so let's go over some E-2 visa developments and adjudication trends. So the first thing I wanted to discuss here is the Buy American, Hire American executive order. So this was an executive order that was kind of announced by the former President Trump, and the main purpose of this order was to kind of protect jobs for US employees. And I would say we saw a big impact that this order had on visas like H-1Bs or L-1 visas, but it did not really impact E-2 visas that much. I would say that the only 2 areas where we saw that it had impact on the E-2 visas were that in the past, the consular officers would want to see that the money you are investing was actually invested in the US and not in your home country. And then the second area was that if you were applying for an E-2 employee visa, the consular officer would often ask, why a US employee is not able to kind of do this job and why you need to come to the US. But in January 2021, the President Biden revoked this executive order, so it's no longer in place. So what has been the impact of the Biden and Harris administration on the E-2 visas? And many people kind of especially in the beginning after Biden became president, many people were asking us will the approval rate be now higher, and what will kind of happen? So I would say that even during the Trump administration, the approval rate for E-2 visas was always pretty high. It was always around I would say 85 to 90%. So E-2 visas, unlike H-1B visas or L-1 visas, were not that impacted by the Trump administration. And I think the main reason was that the E-2 visas, because they are investor visas, people are coming to the US to invest money and to create US jobs. The consular officers, as long as you kind of satisfy the requirements, they were still approving the E-2 visas a lot. So the approval rate so far has not really changed as when we compare it to the previous administration. So now let's go over some changes in consular processing during the COVID-19. So I would say that COVID-19 has had a huge impact on kind of the timeline of getting an E-2 visa at a consulate abroad. So before COVID, it would usually take, I would say, a couple weeks for you, after you submit the E-2 application at a consulate, for you to be able to get an interview and then come to the US. COVID-19 kind of complicated these timelines a lot, but it is also very kind of consulate specific. So some consulates even now during the pandemic are able to give you an interview within a couple weeks after you submit the E-2 petition. But some consulates, it just takes much longer than it used to for them to schedule an interview. So some consulates, after you submit the E-2 petition, you may be waiting for an interview, 6 to 12 months, so much longer than it used to be. But there are consulates that are still very kind of effective and fast in scheduling E-2 visa interviews. And I would say that also because there is currently still a travel ban in place for people coming from Europe to the US. We saw kind of like a big change in that area, because those people coming from a lot of European countries, they cannot get their E-2 visa approved unless they also qualify for what is called a national interest exception. So a lot of our practice this past 1.5 years has been to kind of prepare the national interest exception application along with the E-2 visa application, because the consulates in Europe would not approve your E-2 visa unless you also qualify for the national interest exception. But there has been a great news this week on Monday, when the government announced that the travel ban, all the travel bans that are currently in place will be lifted starting sometimes November 2021. So if your interview is sometimes mid or late after November, you will no longer have to kind of show that you qualify for the national interest exception. So that has been a great news this week. Now the second kind of thing I wanted to discuss is third country nationals applying for E-2 visas, or people applying for an E-2 visa in a country they are not a national of. So before COVID, it was kind of very common that you would apply for an E-2 visa, or really any visa, in a country that you were not a national of, and consulates did not really have an issue with it, and they would usually adjudicate the visa. I would say that has become kind of like more complicated during COVID, just because every US consulate has very kind of like has had limited capacity and limited staff. So they just kind of wanted to primarily focus on providing services to their own nationals. So I would say that many consulates that used to be kind of like friendly, and they were accepting applications of third country nationals, are no longer doing it. So you would want to kind of like double check the venue you want to apply it, if it will be even possible to apply there for an E-2 visa, or if you will have to apply for an E-2 visa in your home country. And then the third thing I wanted to discuss is renewing your E-2 visa in the US, or your E-2 status in the US. So if you are currently in the US already on an E-2 visa, and your I-94 will be expiring soon, you don't necessarily have to travel to your home country and kind of like renew the visa at a consulate, just because, as I mentioned, there are significant backlogs. What you can do is to file a renewal application with USCIS. So this has advantages and disadvantages. The kind of like the main advantage, obviously, is that you can stay in the US if USCIS approves the petition. Kind of the disadvantage, or one thing to keep in mind, is that you will have to kind of submit a brand new application to USCIS. So let's say that even though your E-2 visa was approved back in 2017, and this will be a renewal, you will have to submit documents about the initial investment, about the source of funds, and you just submit a brand new application to USCIS. So that's one thing to keep in mind when you are thinking about renewing the status from within the US. But if you kind of like really need to stay in the US and keep running the E-2 company, and you just cannot leave for a couple of weeks or a couple of months and wait outside the US, that's definitely a good option for you. So now let's go over some issues and complex areas for the E-2 visa. So one kind of complex area may be the source and trail of funds portion of the E-2 visa application. And this is really kind of like an issue or like a complex area if you are applying for an E-2 status with US, if you are filing a USCIS petition, because it's been our experience that most consulates just don't focus so much on the source and trail of funds portion of the application, because the standard for the source and trail of funds is really that you have to show that the money is coming from a legitimate source and it's not coming from a criminal activity. So if you are applying for an E-2 visa, for example, at the US consulate in Toronto, they just want very kind of like limited documentation about this. So for example, if the money comes from your personal savings, they just want to see, you know, the most recent or 3 most recent tax returns, and just kind of want a brief explanation that, okay, this money is coming from your personal savings. But if you are filing a USCIS application, USCIS kind of wants to see an extensive documentation about you know, the sources of funds. So they would want to see the tax returns, they would want to see that throughout the years you were able to kind of accumulate the investment amount on your bank account, and you just would need to submit kind of like much more documentation about the source and trail of funds. Now, loans are fine for the E-2 visa. The only caveat there is that loans cannot be secured by the assets of the E-2 business. So that's the only thing that's not allowed for loans if you're applying for an E-2 visa, but loans can be secured by your personal assets, and that's completely fine. And the investment money can also come from a gift someone gifts you. So it can be from a family member, it can be from a friend, it can be from anyone. But for a gift, we will have to show what's the source of that money. So if someone is gifting you $200,000, we will have to be able to explain where the person who is gifting you the money got the money from. So if the person got it from personal savings, you know, we would need the person's tax returns. If the person got it from sale of a house, we would need kind of like an excerpt of the purchase sale agreement. So that's one thing to keep in mind with regards to gifts. Now, another kind of like issue that sometimes comes up with an E-2 visa is small investment amount. And I think Dustin kind of already talked about this. As we kind of discussed, you know, the investment amount will kind of depend on, or what substantial investment amount will depend on what kind of business you are starting. But in any case, you know, we want to be able to kind of like show why the investment is substantial, and we will have to explain why you know, why the investment amount you made is sufficient to kind of like get this type of business running. And you know, as Dustin mentioned, sometimes especially when the investment amount is lower, we can point to some you know, market research or business articles, or submit a letter from the CPA kind of explaining that the investment you made is substantial, even though it's kind of on the lower side. Another kind of issue or situation that sometimes comes up is E-2 visa for 2 investors. And someone actually already asked a question about this. So it is possible to get E-2 visa for 2 investors if they have to own the business 50-50. So each investor has to own 50%. And I think there are 2 important things to keep in mind here. So first is that if there are 2 investors, then the investment amount definitely has to be higher. and each of you would want to invest kind of like the same or similar amount of money in the business. And then the second thing is that each of you will have to have kind of like a managerial or executive role in the business. So, you know, we had cases when one investor was, for example, the CEO, the other one was CFO or Chief Operational Officer, but each of you has to have that kind of executive or managerial role in the business, because each of you has to kind of independently satisfy the requirement that, you know, you will kind of solely develop and direct the business. So those are some things in mind when there are two investors. Then another thing I wanted to discuss is, so what happens when there are substantive changes to E2 business after you already got the E2 visa? So there can be kind of like two, or what we usually see are kind of like two types of changes. So one is change in ownership. So let's say, for example, that at the time you originally got the E2 visa, you owned 100% of the business, but you know, a year after you got the E2 visa, you now got some business offer and you want to sell 50% to someone else. So that's completely fine. You can do that, but you always have to keep at least 50% ownership in the E2 company. So if you own 100% and you sell 50, that's completely fine. But if you would sell the majority of the business, like 60%, then that would no longer be fine, because you would no longer meet the E2 visa requirements. So it is very important to keep in mind that you always have to own at least 50% in the E2 business. And then the second type of change we usually see is kind of like a change of what the E2 business is doing. Or, you know, people often ask us, you know, so let's talk about, let's take an example. So someone, you know, has a consulting business in the US, and then they reach out to us after they got the E2 visa, you know, and ask if they can open a restaurant in the US. And the restaurant would be kind of like run under the same company. And they are asking if that would be fine. So so here it will kind of depend on, you know, like what was the original, what is the original E2 business doing, and what's the new business doing. So if you are providing consulting services in food industry, for example, then you know, opening a restaurant would be probably fine. And we wouldn't need kind of like a prior approval from the consulate, because the two businesses are in the same field and are kind of like related. But let's say that you are, for example, providing consulting services in IT industry, and you want to open a restaurant, then we would need to submit a new application for that new business. And we would need an approval from a consulate before you can open the restaurant, just because the two businesses are just completely unrelated. So here it will kind of depend what's the current business doing, and what additional business you want to start. And then the last thing I wanted to go over are family business purchases. So we sometimes get kind of clients or potential clients who want to buy a business in the US from a family member, and they are kind of like wondering if that is fine for an E2 visa. So you know, it's not prohibited, that you know, there's nothing in the regulations that would say that you cannot do this. But I would say that it's definitely kind of like much more scrutinized by the consulate, as if you would be buying from the business from a third party. So if you are buying a business from a family member, then we would definitely recommend to submit an independent party evaluation of the business, you know, that would basically kind of evaluate the business and say, this is the fair market price of the business you are buying, and then the money you will be investing should be the same or kind of very similar to that price in that independent third party evaluation. Because let's say that if the business is worth $200,000, but you are investing $50,000, then the consulate could definitely kind of like have an issue with it, because then you are not really investing the money of what the business is worth. Perfect. So now let's go over some common reason for E-2 denials. So the first reason would be low investment amount. If the consular officer just thinks that you haven't invested substantial amount, then they can deny the application for this reason. And I think this is kind of, if you have additional money, you are able and willing to invest. This is kind of an easy thing to fix, because if your E-2 visa is denied, you can always reapply. There is nothing that in the regulation that says that you cannot kind of reapply again. So let's say that the consular officer denied the visa and said that the only reason why they are denying the visa is that you just haven't invested a substantial amount of money. Then you could always reapply, invest more money, and then we had many cases like that, when people kind of like submit the application themselves, then it's denied, then they come to us, we kind of prepare the reapplication, and we have had many cases when the second application was approved. So this would be the low investment amount would be the first reason. Then the second reason we kind of sometimes see is the nature of the business in the US. So some applications are just kind of riskier than other ones. So for example, if you are starting a consulting business in the US and your investment amount is on the kind of like the lower side, and then if you have no signed kind of like contracts with the clients, you have no letters of intent with potential clients, you have no employees, I would say that kind of application is just kind of definitely on the kind of like on the riskier side. So in these cases, especially with consulting businesses, we definitely kind of recommend that the business has at least some letters of intent or some contracts with clients already signed at the time of applying, because otherwise the consular officer can just conclude that the business will not be able to generate enough revenue and employ employees in the US. Then another reason would be the filing location or venue where you are applying. So there are some consulates that are very experienced with, and they have a lot of experience dealing with E-2 visas. They are very knowledgeable, such as the US consulate in Toronto or the US consulate in London. And then there are some consulates that just don't really process a lot of E-2 visas and are not familiar with them. So applying at those consulates may be kind of like, in some cases it may be advantage, in some cases it may be disadvantage. And also one thing to keep in mind is if you are deciding if you should apply at a consulate versus applying at a USCIS. So again, kind of like each has advantages and disadvantages. So with USCIS filings, I would say that the disadvantage or the complicated thing is to provide the source and trail of funds. But then the advantage is that USCIS does not really focus on the investment amount that much. So we had cases where the person, the investor invested around $30,000, and USCIS just does not focus on the investment amount that much. So that would be like one advantage of applying with USCIS. Then,
Michaela, sorry to jump in real quick. I know we are coming up close to 10 a.m. and it's my fault for taking so much time. But just wanted to make you aware if you wanted to touch
Thank
on
you.
the
I'll
key
just kind of
points.
quickly
Yeah,
go over the
sure.
other reasons. Yeah, so then the other reason for denial would be concern over whether the E-2 company is able to create US jobs. Then another reason would be if you already kind of like had issues with the consular officer in the past. So for example, if you kind of applied for a different type of visa or an E-2 visa in the past, and you are applying again at the same consulate, I would say that here usually the consulates try to give you a different officer, but that's not always the case. And then the kind of like the last reason I wanted to mention is, or common reason for denial is if you just did not meet the requirements at the time of applying. So if you kind of invested, $2,000 and had $100,000 on a bank account, then you just did not meet the kind of like the investment requirement for the E-2 visa. Perfect. And now let's just go over quickly the E-2 renewal. So I would say that in the renewal application, the consulates really or mostly focus on two things. So they want to see the company's tax returns to see how the business has been doing, how much revenue has it been earning, and then they want to see W-2s as evidence that you were able to hire U.S. employees in the last couple of years. You had the E-2 visa. And I would say that also in the renewal application, we would basically focus on the tax returns, the W-2s, and then kind of like if you signed any kind of like big contracts with clients, we would kind of focus on those. Or if there has been kind of like media articles about your company, we would submit those with the application as well. And I think that's the most important for the renewal. And we can maybe quickly go over some questions we haven't
Sure.
answered.
Yeah, so I've been typing some responses here that I think most are touching on some of the things that we certainly touched on, Michaela. So
Okay.
in terms of questions that are outstanding, there's really not much, and I do want to be respectful of everyone's time. I think the only question that we haven't responded to directly was the question about whether trainees count as employees. That would depend on the tax status of the trainee. So if they're an independent contractor, a W-2 employee, and I would just say that we in this presentation are not talking about labor and employment law. So you would want to be very careful to comply with whatever laws apply federally, locally, to your employment. So be careful of that. For immigration purposes, you would count people that are on your payroll or that you are paying as independent contractors. All right, Michaela, thank you very much for your time. Thank you everyone for joining us today. We hope the information was helpful. And to quickly wrap things up, you will be receiving an email from us that has a link to our YouTube channel, which has a ton of great information, as well as a link to sign up for future webinars. So we do hope to see many of you on those future presentations. So thank you everyone for your time. Michaela, thank you so much.
Thank you. Have a good day.
You too. Bye-bye.